Mr Speaker, my question is to the Minister of Labour. Why is the government extending the 90-day trial period to all employers?
The Honourable Kate Wilkinson.
Mr Speaker, because the 90-day trial period for small businesses has been a great success. It has given employees jobs they otherwise may not have got, and it has given employers confidence to employ people and grow their business. All over the country, employers and employees are telling me the trial period is opening up opportunities and is being used responsibly. Those sentiments have been endorsed by a report by the Department of Labour that found that up to 40% of employers using the trial period would not have hired the employee without a trial period being available. Indeed, Mr Speaker, just in today's paper there were 2 letters from employers who would not have employed people if it had not been for the very successful trial period.
David Bennett.
Supplementary question to the Minister of Labour. What protections are available under the 90-day trial period?
Honourable Kate Wilkinson.
Mr Speaker, the good faith provisions of the Act apply, meaning all dealings between employers and employees need to be reasonable and honest. Remedies are available to employees in the case of sexual or racial harassment or any kind of discrimination. Mediation is available to the parties to help address any issues that arise. Protections regarding pay, conditions, leave, health and safety are unaffected by the trial period. Mr Speaker, these protections have worked well, and the trial period has generally been used responsibly by employers and employees.
Sir William Seor.
Supplementary to the Minister. How can she claim that this policy has helped those on the margins of the labour market when figures from Statistics New Zealand show unemployment for Pacific peoples has increased from 7.8 to 14%, while unemployment for Māori has rose from 9.8 to 15.4%, and her own department's evaluation of the scheme to date shows that 79% of employees hired on the trial period were European?
The Honourable Kate Wilkinson.
Mr Speaker, this trial period is about giving opportunities to employees and those at the margins, and in fact those hired under a trial period represented 14% of the Maori population. So actually, Mr Speaker, this trial period is about opportunities.
Order, point of order, the Honourable Darren
Speaker, I
Hughes.
appreciate that my colleague's supplementary question contained a lot of statistics, but he clearly was talking about Pacific people, not Māori people, in his question, and her response is not consistent with what his question was.
Order, I beg to differ with the Honourable Member. Sir William Seor specifically also mentioned Māori statistics as well, and the Minister is at liberty to choose some part of the supplementary question that was somewhat lengthy. Has the Minister finished the answer? Rahui Katane.
Thank you, Mr Speaker. To the Minister, how many Māori started under the new scheme and how many, if any, Māori were kept on after the 90-day trial period?
The Honourable Kate Wilkinson.
Mr Speaker, it is not possible to say exactly how many Maori have used the 90-day trial or were kept on after the trial. I expect that, like all New Zealanders, Maori, where appropriate, have and will take up the trial period opportunity because it gives them a good chance to get a job. Can I say, Mr Speaker, as repeated in my earlier question from the Department study, 14% of those hired on a trial period were of Maori ethnicity.
Supplementary question. The Honourable Trevor Mallard.
Do the good faith provisions override the employer's rights to dismiss without giving a reason?
The Honourable Kate Wilkinson.
Mr Speaker, the good faith provisions which have been preserved in the legislation, in particular subclause 1A, it's actually clause 4(1)(a), A and B, the duty of good faith, which is retained for trial periods, requires the parties to an employment relationship to be active and constructive in establishing and maintaining a productive employment relationship in which the parties are, among other things, responsive and communicative. Mr Speaker, that is protected in the trial provisions.
Supplementary question.
Point of order, the Honourable David Parker.
Mr Speaker, Mr Mallard's question was whether those good faith provisions override the employer's right to dismiss without giving a reason. It was a very straight question, it's a very narrow question, and it has not been addressed.
Order. It's an interesting point the member's made. I appreciate that absolutely. I may be wrong here. What I suspect, though, the member is asking the minister is to give a legal interpretation of the statute, and of course ministers are not in a position to do that. Now, the minister has outlined in answering the question what the statute says, and then I'm presuming it's a matter of legal interpretation exactly what that permits and what it doesn't permit, and that's why I believe the minister has reasonably answered the question. I'll hear the honourable member again because it is an interesting issue.
In response to the original question that the government asked of itself, the minister said that the good faith provisions applied, implying that the employer did not have this unambiguous right to dismiss without giving a reason. My colleague asked the specific question from a policy perspective. It's not a legal question. Does the good faith obligation that the minister referred to override the employer's right to dismiss without giving a reason? And it's a very specific and appropriate policy question, I submit.
Well, the point, as the member should be aware of this as a minister, in fact, that if the law doesn't actually say that in those words, then it is a matter of interpretation. And ministers do have to be careful not to seek to interpret what the statute says. And that's why I feel it would be wrong of me to insist on the minister giving a particular answer to that. She's cited what the statute says, and it's up then to interpretation whether that means something can or cannot happen. Is there a supplementary question?
Yes.
The Honourable Trevor Mallard.
Further supplementary. Is it the government's policy, and was it the minister's intention as she introduced the 90-day legislation in 2008 for the good faith provisions to override the employer's rights to dismiss without giving a reason?
The Honourable Kate Wilkinson.
Mr Speaker, the 90-day trial, when it was first introduced, was very specific. It retained the good faith provisions contained in clause section 4, 1A, A and B. It excluded subclause C, which relates to access to information and opportunities to comment, because of the time frames of that, which were some weeks, which were 60 days for reasons, and which would actually have been too prescriptive in relation to the process.
Point of order, the Honourable David Parker.
The question that Mr Mallard asked was whether the policy intention was that the good faith provisions override the right to dismiss without notice. That's the point of contention here. The Minister has been asked this on 2 occasions. It's a central issue concerning this legislation. It's now being applied to all other groups of employees.
I think the member's made his point without having gone any further. The question the Honourable Trevor Mallard asked on this occasion was exactly what was the government's intention with respect to those issues. And I don't believe the Minister has on this occasion answered that question, which must be an answer to what the government intended. And it is a relevant issue where there is a genuine public interest in that issue, and it's not asking the Minister to interpret a statute, it's asking what was the government's intention when it introduced the statute. And I would invite the Minister, if it's possible, if it's in the public interest, to answer that. Honourable Kate Wilkinson.
Mr Speaker, it is the government's intention that we have employment legislation and an employment regime which is flexible and is fair to both employers and employees. The idea of the 90-day trial was so that employers had the confidence to take on new employees, and that employees had the opportunity to get their foot in the door, and if for any reason the employment relationship was not working, then the relationship could be terminated without the need to go through the prescriptive dismissal process under the legislation.
Point of order, the Honourable David Parker.
It would be perfectly permissible for the Minister to say, I don't know. But the Minister has not addressed...
The member is questioning whether or not the Minister has answered the question. And what I might do is invite the Honourable Trevor Mallard to repeat his question, because the question was commendably brief and to the point. I invite the Honourable Trevor Mallard to repeat his question.
The first bit will not be an exact repeat because I didn't have it.
Insofar as the member is able.
Was it the government's intention, as they introduced the 2008 legislation, for the good faith provisions to override the employer's rights to dismiss without giving a reason?
The Honourable Kate Wilkinson.
Mr Speaker, the government's intention when we introduced the 90-day trial